is part one of the state capture inquiry's report. More than 1,400 people and entities implicated by evidence led before the inquiry. Just over 3,000 summonses were issued, 75,000 pages of transcribed oral evidence recorded, and information on corruption and fraud will be availed to law enforcement agencies now for further investigations. Let's bring in legal expert Nthabiseng Dubazana, who joins us now for a way forward in holding those implicated to account. Nthabiseng, thanks very much indeed for your time this morning on the AIM report. So the official word from government is law enforcement agencies can start using the state capture inquiry report immediately to pounce on implicated individuals. You know, I suppose the question that South Africans will be asking this morning is, did they have to wait for this first part of the report? Surely there was ample evidence to do so already.
Wait until now, and remember previously until the president had changed the regulations in terms of the Commissions Act, you couldn't use evidence that was being alluded or given in any commission of inquiry. And then he amended that to say that as long as it's information that is used to incriminate yourself, it cannot be used, but that gives the window that any other thing can therefore be used in order to investigate, for the NPA to investigate and then formulate a charge on its own. So with the evidence that has been going on since 2018 to date, there's more than enough evidence, I'm sure, that was available to the NPA in order to use for investigations and open charges against individuals. But I suppose there's reasons why they decided to wait this long before they proceed with anything else, or perhaps there is no communication between the NPA and the Commission, whether or not they've already started their own investigations in order to arrest the likes of Dumeni and all of the people mentioned in the report thus far.
Yeah, I mean, there's a mountain of evidence before law enforcement agencies at the moment. 1,400 people and entities implicated by this evidence, summonses, 75,000 pages of transcribed oral evidence. There's also a mountain of forensic evidence. You know, yes. Do we have the capacity to go after this kind of, or to act on this kind of evidence that is now before our agencies?
Honestly, looking at our current court structures and the people or manpower that is available, I don't know if we can. I don't know if we'll be able to see any prosecutions happening within the next year or two. When you look at just our normal court roll itself, our prosecutors are overwhelmed in the lower courts. Remember, these cases are going to start in the lower courts and obviously work their way up as a result of cases still happening, unless there is a reasonable explanation why it can go directly to the High Court. But in any event, if it goes directly to the High Court, that is also backlog upon backlog of cases. So when you look at forensic evidence as well, there's backlog there as well. For example, if you get arrested today for drunk driving, to get your blood report back takes about 9 months. So if we look at such situations, we are looking at a situation where we're not going to see any prosecutions happen between the next year or two, because we don't have that kind of capacity, and most likely we don't have the kind of resources to deal with that kind of evidence.
I mean, you're talking about drunk driving and the processes and the delays that are in place there. When it comes to this kind of forensic evidence that does need specialist know-how on a way forward, you talk about a year or two, it may well be longer.
It may well. We don't have a lot of experts in certain areas when it comes to certain forensic evidence that needs to be dealt with. Sometimes, if not most times, we have to fly them in from out of the country. And that is already an expense that currently with our economy, I suppose, we cannot afford to do that. As is the NPA, in order for them, because it will be upon the request of not only the NPA, but also of SAPS. They don't have that kind of manpower or rather financial backbone to get somebody to come into the country and deal with that kind of forensic evidence. And that person, remember, they still have to stay and be asked questions by the attorneys and prosecutors to understand how they got to those conclusions, what do they mean, and also to have authenticate that they have those qualifications and all of those. We're looking at a very, very long process if it will ever get to court at the end of the day.
So let's shift tack for just a moment, Nthabiseng, and talk about, you know, if I am an implicated person in this first part of the state capture inquiry's report right now, are there any steps that I should be taking in terms of, I don't know, preparation, whatever that might be, or do I wait?
So once it's made officially public, well, everybody has it by now, I suppose, but then you can now, if you feel that the report is biased against you, or you feel that things were not articulated the way that you would have wanted it, there's a process of reviewing the report. So you can now, we're going to look at a number of legal cases from what I can see, whereby we're going to see people taking it to the High Court and asking for it to be reviewed because of 1, 2, 3, 4. And now once the review stage in the High Court has been done and it doesn't go my way as Nthabiseng, who's implicated in the report, then I can take it to the SCA all the way to the Constitutional Court. So we're going to look at that string of legal things happening before we get to the issues of the criminal aspect that is coming out of the Commission of Inquiry.
Sounds like an incredibly long road ahead. The release of this report it's part 1 and it's phase 1 of the legal processes that are to come.
Yes, 100%. I think we're just going to sit back and, get some popcorn and watch and see what's going to happen, because it's only the beginning. Everybody who's implicated there is going to want to try and defend themselves in one form or another. And that regulation that was amended by the president in 2018, that if there's evidence whereby you incriminate yourself, it cannot be used. A lot of people, I do believe, are going to use that as a form of, you cannot open criminal charges against me because I incriminated myself. And per this section, you cannot proceed with criminal charges against me based on that specific oral evidence that I gave on that day.
Well, they've just gotten some free advice from you this morning, Nthabiseng. Before we let you go, I want to talk to you about some of the recommendations that are contained in the report. And one of those is this issue around deferred prosecution agreements for companies that do cooperate from here on. What does that entail?
A deferred prosecution whereby if we sign, what's that section? I forgot the name, the exact section in the Criminal Procedure Act. But if there's an agreement between the state and the accused, in that you will assist that, it's sort of like a Section 204 witness, but for companies. And then we come to an agreement that if you give us certain information, we will defer prosecution in the event that it leads us to the position that we want. In other words, we are able to get Nthabiseng, who is the actual person that we want, from the evidence that you're going to give us. Then we will defer, which can be for 3 years or forever. But if we don't get what we want, we will still proceed with prosecution, prosecuting you as a result of lack of information or lack of arrests from the information that you gave us. So
the aim there is obviously to net a much bigger fish in the grander scheme of things.
Yes.
Nthabiseng Dubazana, let me thank you for your time this morning. Thanks very much for joining us as we try to understand the legal way forward insofar as part 1 of the State Capture Inquiry report is concerned. 1 million gigabytes in data with information on corruption, fraud and state capture now available to our law enforcement agencies.